I see we've reached our limit. Permission to begin?
Over to you.
Thank you very much. Our esteemed seniors of the profession, fellow colleagues of the bar, good afternoon and welcome to a session proudly convened by our Judicial Service Commissioner, Honorable Omwanza Ombati. First of all, thank you so much for taking time to come with us. Before I introduce myself, allow me to make this announcement. We seem to have reached our limit. Therefore, we humbly request that you redirect the rest of our colleagues to the YouTube page. Our YouTube page is under Omwanza Law Series. Kindly in your WhatsApp groups, please leave a message that we are still live on YouTube and they should be redirected to the Omwanza Law Series YouTube page. Thank you. So my name is Karen Rono, your fellow colleague in the profession, proprietor of Chelagat Law Advocates, and I have the distinct pleasure today of serving as your moderator for this session. It is my great honor to welcome you to this insightful conversation, but equally before I set the basis for the conversation, it is important for me to introduce the team that allows these conversations to continue. So I can see my seniors. There is Chrispin Bosire, who I think I can see right on my screen. We have Mr. Jared Gekombe, again in no particular order, but Jared as my senior, then proceed to Chrispin and Atieno Ogolla. Thank you so much for taking time each month to organize for this particular set of conversations that have really helped in mentorship in one way or another. With that, it is my great honor to welcome you again to this conversation on enhancing effective cross-examination by advocates during trials. Today, we are privileged to hear from one of the most esteemed minds in our judiciary, a legal luminary whose judgments have shaped and defined the contours of our jurisprudence, Honorable Justice Odunga. Cross-examination is often described as the engine of truth in our adversarial system of justice. It is where the skill, precision, and strategic acumen of an advocate are put to the ultimate test. Yet, despite this importance, cross-examination remains one of the most challenging aspects of trial advocacy. It is an art that not only requires mastery of the facts and the law, but also an acute understanding of human psychology and behavior. In today's session, His Lordship will be sharing his invaluable insights on how advocates can enhance their cross-examination techniques and tactics to achieve effective outcomes in trial. His extensive experience on the bench and profound understanding of trial dynamics make him uniquely qualified and able to guide us to this critical aspect of legal practice. But before that, rules of the profession prohibit me from inviting him and introducing him. Therefore, allow me to bring on board our team lead, who proudly convenes this particular conversation and someone I hold in such high regard and who has taken time during extensive deliberations of JSC to join us today. Just to confirm whether Honorable Omwanza Ombati is on call and able to introduce His Lordship. Thank you. I can see the Chief Registrar behind there. Yes, I'm boosting you.
You can come and say hi.
Yes, please. We will really appreciate it. It is an honor.
Yeah. Okay. The Chief Registrar can say hello.
Wow. Hello, how are you?
Hello.
Fine, thank you.
Fine. I'm happy to be. Oh, Judge, how are you?
Fine, thank you, CRJ.
Fine. I've just been called in. I'm yet to understand what meeting it is, but I'm saying hello.
All right.
Yeah. Okay. So I will excuse myself for now.
Thank you. Thank you. That was the CRJ. We were having a commission meeting. She's excused herself. Thank you, Karen, for that introduction on the topic that we are going to discuss this afternoon. I first want to thank Justice Odunga for finding time to come and give this presentation. Justice Odunga is known to us all. In fact, the other day I got to know that he was one of the group that is called the Mercedes-Benz Judges. and he might not remember this, but in 2008, when the Chief Justice, I think Evan Gisheru, issued a directive that constitutional matters will only be filed in Nairobi. We filed a matter with him. Then he was a practitioner in Kisumu, in Behan Okero. And that matter was resolved. But besides that, is a very interesting writer, and I will do enjoy his books, but also his judgments. Judge, I remember one of the interesting judgment. I think it was the Wavinya Ndeti judgment, whereby you say that judges are not angels who go to heaven on Friday and come back to earth on Monday. So he has a very interesting interpretation about the law, and we all enjoy what he writes. So I would proceed and introduce him. Justice Odunga is a judge of the Court of Appeal, and he's stationed in Mombasa. He was formerly the presiding judge at the Judicial Review Division at Milimani, Nairobi. He served in Machakos and also the commercial and civil divisions of the High Court in Nairobi. He was admitted to the role on 23rd of February, 1995, and is a former partner at Behan and Okero. He was appointed, I think this was the first appointments of judgeship to the bench after the 2010 constitution. That was on 23rd of August, 2011. He's the chair of the Mediation Accreditation Committee, which is a statutory committee within the judiciary established under Section 5(9) uppercase A of the Civil Procedure, and he's also chair of the Rules Committee established under Section 81 of the Civil Procedure Act. He was also in the Rules Committee as a member of the Law Society, I remember, for a long time. He's a member of the Judiciary Management Committee, served at the High Court Advisory Committee, the Employment and Labor Relations Rules Committee, and the Inaugural Technical Committee on the Supreme Court Rules. He represented the judiciary in the committee that was tasked with the enactment of the architecture of courts under the Court Martial Act in the Kenya Defense Forces Act. He's a member of the International Refugee Law Judges Association, African chapter, and he has authored Odunga Digest on civil case law and procedure, which comprises of 10 volumes. Please, if you do not have that, then I don't know what you're doing. He's an awardee of the Law Society of Kenya Distinguished Award in the Administration of Justice 2015, and also 2018 ICJ Jurist of the Year Award, and 2023 Transparency International Kenya Judicial Integrity Award. I have the pleasure this afternoon to introduce him, and I'm here also to learn, like all of us, in this webinar, and I'm looking forward to this session. Thank you, Justice Odunga, for finding time. I hand over the session to you.
Thank you, Commissioner, and thank you, Mr. Rono. Good afternoon, colleagues. Am I audible?
Yes, Judge.
Yes, you're audible, Judge.
Okay, thank you very much. It's really a pleasure for me and with the humility to be here this afternoon for us to talk about issues cross-examination. Cross-examination is usually is one of the subjects that I hold dear because I've seen a problem sometimes in cross-examination that we may need to talk about. Not that I'm an expert in cross-examination, but just this presentation is just a forum for discussion so that we exchange ideas on how best to conduct cross-examination. I'm not sure that cross-examination is one of the ways of successfully concluding a trial, but maybe at the end of this presentation, we'll make a decision whether it is or it is not. Now, my presentation is divided into a few areas. The first area that will deal with is statutory evidential provisions that deal with the cross-examination. Instances of cross-examination and matters in which cross-examination may be conducted. Then aims and objectives of cross-examination. Then techniques of cross-examination. And then preparation and some rules of practice when conducting cross-examination. The question that comes to one's mind, usually after examination in chief, is should I or should I not cross-examine? Most practitioners agree that the rule of the thumb is that if you are in doubt whether or not to cross-examine, then do not do it. Don't take a chance in cross-examination if you are not sure that actually that's the best thing that you want to do. The reason is very clear. Cross-examination is a double-edged sword. It may cut the prosecution, it may cut the defense. It may also cut both the prosecution and the defense. So if you are not sure who the sword is going to cut, you better not touch it. Every question in cross-examination is usually an invitation to disaster, because it is an opportunity for the witness to hammer you and hammer your case. And that's why it's advisable that if your case has not been damaged by the evidence given by a witness, leave it. I will see how to go about this to avoid getting in those kind of pitfalls, and how to see whether you can be able to conduct a cross-examination without exposing your client to a possibility of losing a case in a civil case, or sending your client to the gallows. So we start with the cross-examination and its instances. Of course, we are aware that cross-examination is one of the types of examination of witnesses that is prescribed in section 145(2). And it is described as examination of a witness by the adverse party. Generally, cross-examination follows examination in chief. I'm saying generally because there are certain instances when it doesn't follow that cross-examination comes after examination in chief. And these exceptions are where the court permits the introduction of a new matter in a re-examination. Sometimes in the examination, the plaintiff's counsel, the prosecution counsel introduces a new matter which was not covered in examination in chief. Rarely, but with the leave of the court, you can do that. When leave is granted, then of course the defense counsel has an opportunity to cross-examine on that new matter. The second instance is where the court allows for the recall of a witness for further examination in chief under section 146(4). Then in that event, there's an opportunity to cross-examine and also re-examine. Thirdly is where the court in its discretion permits a person who called a witness to put to him questions which might be put to an adverse party. In other words, where you declare your witness to be hostile. Then in that event, what was supposed to be examination in chief suddenly turns to be a cross-examination. Now, it's important to have a clear distinction between a hostile witness and an unfavorable witness. A witness is not hostile merely because he or she is not answering questions the way you want it. A witness only becomes hostile when the evidence that is expected to give is totally different from what is giving in evidence. A witness, you may call a witness, and suddenly you find that the witness is giving evidence in support of your opponent's case. That is what we mean by a hostile witness. Otherwise, simply because a witness has agreed with some of the issues raised by the other side does not amount to that witness being a hostile witness. The general rule according to section 146 of the Evidence Act is that the examination in chief and cross-examination must relate to relevant facts. That's what is provided in 146.2. Now there's a problem with the version of the Evidence Act that I downloaded. I don't know whether it's the current one or it's been amended. That section says general rule is that the examination in chief and cross-examination must relate to general facts, but cross-examination need not be confined to facts which the witness testified in examination in chief. So whereas all the three types of examination ought to be related to relevant facts, cross-examination is wider. It may go outside the evidence in chief as long as the questions that are being asked are relevant. So unlike in examination in chief and re-examination, where leading questions are expressly prohibited, that is if objected by the other party, unless leave of the court is granted, in cross-examination, leading questions is the order of the day. The court may, however, allow leading questions to be asked in examination in chief, where the matters are merely introductory or where the matters are not in dispute. When you, for example, you ask a witness that is your name John or Joseph, and there's no problem, no contest about it. That should not cause any problem at all, although that is a leading question. Because sometimes you find that you ask your witness that, can you tell the court your full names? And your witness tells you yes and keeps quiet. Then you don't know what to do with the next question. So where the question really is not the answer is not in contest, you may be allowed to ask a leading questions where there's no dispute at all as regarding the issue. For example, the case you have is a divorce case, and the issue of the parties having been married is not in contest. The year of marriage is not in contest. Then nothing is wrong with you asking whether are you married to so and so, and were you married in this particular year? Nothing wrong with that. So issues such as names, status, those ones may be asked with the leave of the court. Of course, a leading question is any question that suggests an answer which the person putting it wishes or expects to receive, or suggesting a disputed fact to which a witness is supposed to testify. I've seen sometimes counsel believing that leading questions can be asked in re-examination. That's not the position. The rules relating to examination in chief apply with equal force to re-examination. Now, which matters should examination be conducted? In cross-examination, you are permitted to ask the witness about previous statements. Those are the statements that were made by that witness in writing or were made and reduced in writing, as long as those statements are relevant to the matter in dispute. If that's the only thing that you're doing, you don't have to show that witness that statement. But if you intend to use that statement to contradict that particular witness, then you are required to show the witness the particular statement, the previous statement that was made by that witness. When you do that, then that whole statement, if it's a statement, you don't just refer to particular paragraphs and restrict yourself to it. You may do so, but once you introduce that particular statement, the whole document becomes admissible. It becomes admissible and may be a subject of either cross-examination or re-examination. So a distinction is created here between cross-examination as to making of a statement and where cross-examination goes to the contents of that statement. You may, however, ask a witness any question that test his accuracy, the veracity or credibility. You may ask questions that go to discover who he is and what his position in life is. You may ask questions that shake his credit, even if to do so would amount to injuring his character. And even where the question might tend to directly or indirectly incriminate that particular witness. However, where the question tends to affect the credit of the witness, then you must be take into account Section 155 of the Evidence Act. That section applies Section 128 of the same Act, in that no answer which that witness is compelled to give is to subject him to any arrest or prosecution. And that answer cannot also be proved against that witness in criminal proceedings, save for where those proceedings relate to giving of false evidence, that is perjury. However, where a person is charged with an offense and that person is called as a witness for the defense, he may be asked questions regarding, notwithstanding the fact that the answers may tend to incriminate that particular witness with respect to the offense charged. That is where the person is also charged. You should, however, not ask questions unless you have reasonable grounds for thinking that the imputation which it conveys is well-founded. That's very, very important. When you are examining witness on matters which I think may tend to expose that person to criminal charges, you must be careful to ensure that the question is well-founded and the imputation of that question is also well-founded. Where an accused person gives evidence, he should not be asked questions that tend to show that he has committed or has been convicted or charged with an offense or that is of bad character, unless he has himself put his own character as part of his case. And of course, if you are dealing, for example, with a matter of a defamation basically depends on reputation. So if a matter is with respect to defamation, obviously reputation is at the core of that matter. And therefore, questions regarding reputation will become irrelevant. Again, where the witness has attacked the character, the accused person has attacked the character of a prosecutor or prosecution witness, then that opens the accused person to questions regarding past conviction and bad character. This is important because if you are appearing for the accused person, and in your cross-examination, the prosecution witnesses, you take issue with their bad character. Remember that you are exposing your client to his character also being brought into question. So that unless you are prepared to expose your client that line of questioning, you are better advised not to take up issue with the characters of the prosecution witnesses. Again, that rule doesn't apply where the accused has given evidence against a co-accused charged with the same offense. The answers given to questions relating to credit, however, are final, and you are not supposed to adduce evidence to dispute them unless the evidence that you want to adduce relates to bias or the previous conviction where those are relevant. The court, however, has the power to stop you from asking questions or inquiries which the court regards as indecent, scandalous, and that notwithstanding that such questions may even have a bearing on the question before the court, unless they relate to matters which are necessary for the court to be known in order for the matter to be determined. Questions that appear to the court that is intended to insult or annoy, or which though proper themselves appear to be needlessly offensive, are also forbidden. This to ensure that the cross-examination is not turned into a forum for abusing witnesses. Witnesses don't come to court to be insulted or to be abused unnecessarily so, unless their character is brought into question. The court may permit a question which may, although not relevant to the proceedings, affect the credit of witnesses. The court may not permit a question where the question affects the credit of our witnesses, and in that case, the court may warn the witness not to answer a particular question. However, where a witness decides that the question is not really, that doesn't really affect the evidence, nothing stops the witness from proceeding to answer it. Do we then deal with the aims or objectives of cross-examination? Of course, the obvious aim or objective of cross-examination that all counsel believe in is the destruction of the material part of the evidence in chief of either a particular witness who's giving evidence or even the evidence of other witnesses for the other side. Sometimes you find that you employ cross-examination when you are questioning A to destroy the evidence that had been given by B, or vice versa. Now, this kind of aim or objective, more often than not, we only see it in mock trials, those ones that you see on TV. Those are where they work very well. In real life, it doesn't work that way. You'll try to destroy a witness as much as you can with all your strength. The witness will fight back tooth and nail, confound you until the objective that you set out to achieve, you find is totally unachievable. Witnesses will deliberately misunderstand your question. They will formulate their own answers to the question. They will give you evasive answers, so that the ideal is not aimed to lead a witness to admit that, for example, the evidence that is giving is untruthful or mistaken, but only to expose that witness, that evidence, as not being reliable at all. Litigation counsel will tell you that examination alone cannot be relied upon to win a case that is otherwise hopeless. Cross-examination is only meant to bring out weaknesses which may or may not themselves be decisive. So even apart from rare cases where you may find that a witness evidence is being destroyed by cross-examination, in most cases, it doesn't happen. It's therefore important that you ensure that apart from cross-examination, you have witnesses who are going to support the line of questioning that you adopted. Ensure that your side's evidence is fully presented in evidence in chief, and then you just regard the answers, the favorable answers that you get in cross-examination as a bonus. The second aim of cross-examination is, of course, to weaken the evidence, which I've alluded to, and this is your best bet. You try to reduce the weight of the evidence and qualify the inferences which might be drawn from that particular evidence, particularly where the case depends on circumstantial evidence. You may, in cross-examination, bring in the existence of other explanations that may reduce the weight of the circumstantial evidence. In matters of identification, your cross-examination may tend to introduce a possibility of a mistaken identity, so that you try to weaken the evidence that is being adduced by the other side. It's therefore important to note that discrediting with evidence is not the same thing as discrediting a witness. It does not require that you attack the person giving it. You only attack the evidence that is being adduced. It's very important to note that as an advocate, you must try as much as possible to judge the character of the witness that is giving evidence, taking into account the fact that people perceive events differently and from different viewpoints. People remember different things. There are different ways of viewing what is important. What is important for one person may not be important to the other person. They have varying skills in communicating what they have witnessed. As a result, you may find that there are often discrepancies in the evidence given by witnesses, even witnesses who witness the same event. This is not necessarily evidence that that witness is attempting to mislead. And therefore, attacking the personal integrity of a witness in those circumstances is unlikely to achieve the result that you intend to get, and sometimes may put you in bad standing with the court if it's clear that the witness giving evidence is simply mistaken, not trying to mislead, and yet the line of presumption adopted is the one that attacks the person of that witness. You can't diminish the value of the witness by simply questioning, highlighting the facts and circumstances which render that evidence unreliable or less reliable. It said that a witness can be honestly mistaken, therefore you must take that into account. Explore the opportunity, that is circumstances under which that witness saw, had, and experienced what is trying to recount, whether the circumstances prevailing were conducive to an accurate perception or recollection, possibility of bias, whether the witness has an allegiance to any of the parties, which would cause that witness to take sides even without realizing it. Test the recollection, any particular reason why the witness took notice of the events at that particular time, or the reasons why the witness remembered what took place, and whether any note or statement was taken at that time or immediately thereafter. How long it took that witness to recall the event, any suggestions from another person which may have tampered with the recollection. A number of times when you are dealing with two witnesses who saw the same event, it may be that after that event took place, the two witnesses sat together comparing notes, and one of them reminded the other witness that, oh, we also saw this particular thing. So that may come out in cross-examination. A witness may tell you that, yes, this one was mentioned to me by my colleague later on, but I did not see it myself. The issue whether the witness is recounting the evidence in his own words or based on what another person told him. All those are issues that you need to take into account when the objective is to weaken the evidence that is being presented by a particular witness. The third objective is to elicit new or fresh evidence. Since in cross-examination, you are not limited to the evidence that has been given in examination in chief, as long as it's relevant, you may be able to elicit fresh evidence, and this evidence will help you in building your defense, such as the defense of alibi. To succeed in this particular aim, you ought to be courteous to the witness, because you are trying to get as much help. You are the one who needs help from the witness, and the only way to ensure that you get that help is to be courteous to the witness. Lead the evidence gently to the answers that you want by asking leading questions, and when you get favorable answers, bank those good answers. By banking means that once you get an answer, leave it. Sometimes counsel become too greedy. They have achieved what they want to achieve, but they start asking many questions thereafter. And you may just end up destroying what you have already achieved in the earlier questions. The fourth objective of cross-examination is to undermine the witness. This is the one this is where you now want to check the credibility of the witness by showing that that witness cannot be trusted to speak the truth, or that that witness is speaking into matters which he has no real knowledge about. This ought to be employed as a last resort. It's only aimed to destroy or diminish evidence that is adverse to your client. So that where there's no evidence that has been adduced that is adverse to your client, you better not resort to it. It's again also aimed at showing bias, interest in the outcome of the case, discrepancy in the evidence, inconsistency, and reputation. The fifth objective or aim of cross-examination is really to parade your case, to put your version of the disputed facts to the witnesses to comment on those facts at that early stage. I think one particular aspect of a hearing that some of us tend to forget is that a defense case commences from cross-examination. Your case starts from the time that you start conducting cross-examination. And therefore, it's important that you put as much of your case as possible to those witnesses who are reasonably expected to be able to answer. You don't have to put your case to each and every witness. You only put your case to the witness that is relevant for that particular question. Again, only put that question to our witness whose evidence conflicts with the version that you've been given by your client. It's usually advisable not to put a version to a witness if you are not going to call a witness, you are your own witness to dispute the version of that particular witness. And we will come to this, the preparation. Why it's important to do preparation before you start the examination, because it's important when it comes to the issue of not putting questions that you don't intend, or you don't even know whether you have witnesses to support. What then are the techniques of cross-examination? Just a quote from Lord Morgan, and this is what he says, I quote, "Many a counsel has risen to his feet, wishing that the system of cross-examination had never been invented. He must ask something, but what? Many counsel content themselves with asking over again a few questions which have already been asked, and then sitting down, avoiding, if possible, a sigh of relief," unquote. Trial, the whole trial is an art in persuasion. Whether you are prosecuting a case or you are defending a case, ultimately the objective that you have in mind is to persuade the tribunal that hearing your matter to side with your client's case. Now, how do you deal with this? What are the techniques that you may adopt? It's important that cross-examination be orderly, though it's slightly loose than in examination in chief. The principles of clarity, thoroughness, and orderliness ought to permeate the whole texture of cross-examination, whatever the technique you choose to adopt. The first technique of cross-examination is confrontation. You confront the witness with the damaging facts, which you are sure the witness cannot deny. And if the witness were to deny, then that denial will be inconsistent with that witness's testimony. Of course, this is a technique where you apply when you want to destroy the evidence of a witness, but it may also be applied in appropriate circumstances to weaken the case for the other side. It's however important that you only employ this technique where you are sure that you have strong material at your disposal. It ought to be based on already proved evidence or evidence that you intended to prove. It's usually effective in a case with a large number of documents that are meant to be used against a witness. Some counsels start with the least damaging points and then reserve the most effective evidence in order to give what you may call a finishing stroke. It's most effective in exposing a deliberate liar and where plenty of evidence is available. Let me give an example of a true case. The evidence of a pathologist conducting cross-examination, where the evidence was that all the organs as examined were found to be perfectly in order. So what happened was that the advocate knew that that was not the position. Of course, the advocate is not a pathologist, but there are facts that had been placed at the advocate's disposal and he was aware of them. So he started by being dramatic. He asked the doctor that before you started the postmortem examination, you examined the general body. And of course, the answer is yes. Let's take it that you went to where the head was. You examined the body. Yes, I did. You went to the side. Let's start with the left side. You went to the left side. Yes, I did. Then you went to the right side. Yes, I did. And you went to at the feet of the body and you also examined. Yes, I did. And let's also assume that in order to carry out a proper postmortem examination, you must have removed some organs. And he said, yes, I did. You removed the lungs, examined, did that. You examined the liver, I did that. And then you also examined the kidneys. Yes, I did that. You looked at the left kidney, I did. Looked at the right kidney. Yes, they did. And they were perfectly in order. Yes, they are perfectly in order. So after all that, the advocate then asked the witness, would it surprise you if you are told that one of the kidneys of the deceased had been removed 5 years before his death? Now, that's a question that you can only ask whether you are going to give evidence that that kidney was actually removed. Because if you have that question and you don't have evidence, then you might end up in trouble. But you see, that's the kind of evidence that will now, the witness will be completely shocked, particularly if that witness did not even conduct the post-mortem examination. So you see, you start by probing, and then you come to the last question, the most important question. So in some areas regarding this particular technique, it should not be used without strong material, preferably where the facts are not denied. The facts should be put to the witness one at a time. As soon as each fact is admitted, all its damaging implications should be drawn out one by one. If a witness offers lame explanation, it should be precisely pinned down. The other facts are again put in turn in such a way as to demolish the explanations. And the aim is to force the witness to admit the falsity of the story and involve that witness in contradicting himself or herself. The second technique is the one for probing. This entails inquiring thoroughly into details of the story in order to discover the flaws, and is aimed at weakening or destroying the evidence of the witness. This one you can employ without necessarily having any material for cross-examination, because it consists simply delving into the story as told, so that you aim to detect and expose the inherent weaknesses of the story. Probing may be used as a starting point before you move to the next technique, which is insinuation. Insinuation is the building up of a different version of the evidence in chief by bringing out new facts and possibilities, so that while helping to establish a positive case in your client's favor, you are at the same time weakening the evidence in chief. It may take the form of quietly leading the witness on little by little. It may be gentle, it may be firm. And sometimes it's the most important of all these techniques. The fourth one, jurists and legal practitioners are not agreed whether it's a technique or not. The one of undermining the witnesses. Its aim is to break down the evidence by inquiring into the facts in order to take away the foundation of that evidence. That is examining the credit of the witness. So you are not attacking the evidence, but you are attacking the foundation of that evidence. It is, however, important that caution be taken when you are dealing with an expert witness, unless you are so certain about the qualifications of an expert. It's advisable that you do not question the qualification of that witness unnecessarily so. The safest course is to search for a collateral matter which the witness ought to know if that witness is a real expert, so that you do not attack the qualification, but you attack rather the credibility of the witness's evidence. Because if you bring a matter where ordinarily an expert ought to know, and it comes out that this particular person who claims to be an expert doesn't know that matter, it dents the evidence of that particular witness. I then wish to proceed to deal with the preparations. As I said earlier on, defense evidence, the defense case starts with cross-examination. So unless you know the case, your client's case well, it's almost impossible for you to conduct a successful cross-examination. Because which case are you going to put to the witness if you yourself do not know what your client's case is? It's therefore important to ensure that you take instructions from your client before you start cross-examination. Whereas this is not a big problem in civil matters, it's a big problem in criminal matters, where, for example, your client is in custody. It is important to try as much as possible to have a conference with your client so that you get to know the nature of your client's case. You must remember that in any case that you are handling, the liberty, the life, the property of your client is at stake. For your client, that is the most important case. It could be the most important case in his or her life. And therefore, every case that you take, ought to take it with the seriousness it deserves. Even one day that a person spends in prison, when it's not justified, is too long. So it is important that you prepare your case in advance, you know your case in a good time, so that you are able to put relevant questions to the witness, not only to destroy, to weaken and all that, but also to ensure that your case is brought out well in advance at the time of the hearing, the evidence in chief. Cases have been lost because of the failure by the defense counsel to put the defense case to the witness. A number of cases you find, for example, in the cases that we call them the Romeo and Juliet cases, where you find, for example, the accused is just 18 years, the complainant is 17 years. Technically, that is a defilement, a case of defilement. But depending on the region, for example, where you come from in this country, there are regions in this country where 17-year-old girls are, them they believe that they are ready for marriage. And when they enter in that kind of a relationship, they completely see nothing wrong about it. In fact, to them, when they come to court to give evidence, they tell you that I'm married. Parents literally have to drag them to go to the police to record statements. And when they come to court, they don't see any reason why. They don't even understand why the case is in court. Now, in that case, maybe if you are to take instruction from your client may say that we are married, and I had everything to believe that the complainant was 18 years or over 18 years. A defense that is available in law. Of course, there are certain cases where even if you raise that kind of defense, nobody will agree with you. But there are cases where that defense applies. Now, if you did not take your client's instruction in good time, there's no way you are going to bring out this particular defense in cross-examination. The questions of alibi, if you do not bring that question to the prosecution witnesses, you don't take it up with prosecution witnesses when giving evidence in chief. Most likely, when you bring that evidence in your defense case, the court will tell you that that was an afterthought. And sometimes you end up that your client loses a case simply because proper instructions were not taken before you started on cross-examination. And that now brings me to the rules of practice. As much as possible, and this relates to the last matter I've talked about, as much as possible, cross-examine all the material facts which are disputed. Otherwise, the court may take it that the evidence is not disputed. Put to the witness the case you are going to set up, so far as your case lies within the knowledge of that particular witness. Because this is a necessary preliminary, the calling of contradictory evidence, so as to avoid what I've mentioned as a feeling that the evidence is simply an afterthought. If you intend to lead evidence to contradict the witness, or you intend to argue that the evidence should not be accepted, you have a duty to cross-examine the witness on those disputed facts. There's also a grave risk that in not cross-examining witnesses on disputing facts, the court may accept the evidence of that witness. Of course, there are witnesses whose evidence really is nothing much turns on them, and you don't have to bother yourself with the cross-examination. Avoid merely suggesting two or putting two. Something which is very common in cross-examination. I put it to you. I suggest to you. The result of such kind of examination is that you will only get denials. That's all you'll get. I put it to you that you are lying, and the witness tells you I'm not lying. Doesn't really help your case at all. You ought to insinuate your case, build it out to the witnesses, let that issue come from the mouth of the witness so that the court can record it. For example, when you ask a witness that I suggest to you that you did not see what happened, and then the witness tells you that I saw it. I mean, what do you expect the court to record? The court will record that I saw it. So ensure that the evidence comes from that particular witness. Avoid going over the story which has already been told by witnesses, merely in the hope that if you insist and you put pressure, the story will be altered. Unless you are sure that the witness is lying or has been coached. If a witness insists on the version that he has already said, the more that witness repeats it, the stronger the evidence becomes, and the weaker your case also becomes. because the court may find that the consistency of the evidence is proof of the truth of that particular evidence. A critical question that may decide the case adversely should not be asked unless the answer is known. There are questions which are 50-50. If they are answered in your favor, you get a very good answer. If they are not, your case goes into smoke. Approach such questions cautiously, little by little, so that you are able to gain some idea of what the answer is likely to be. Though taking a risk may not be avoidable, it must always be a calculated risk, not one that is you recklessly get into. Since nowadays the statements are exchanged in advance, it's easier for you to know the likely answer that you will get from a witness. But still, you must ensure that you are certain that that's the answer that you are going to get. For example, you find in criminal trials, the witness has given evidence but has not identified your client. In cross-examination, you can do either of two things. You can leave it at that and then submit on it. You can take a risk of ensuring that you get the answer right by asking that particular witness, did you see my client at the scene? If the answer is no, you are home and dry. Sometimes the witness remembers, and instead of just saying that, yes, I saw him at the scene, he goes further to say, yes, he was at the scene, and he was the one who was carrying a panga. You are down completely. There's no way you are going to save that particular case. Your case, you have literally sent your client to jail by trying to be too sure that you get the right answer. Avoid an overkill. Avoid unnecessary questions. When you have already obtained good results, it's always possible that by a question intended to clear that matter, the whole effect may be spoiled by opening an avenue for witness to explain himself. In that event, you may end up having to start all over again, trying to destroy the monster that you have created by your own zeal. I've had instances where you find that an advocate asks a question that ought not to have been asked, and has received a negative answer or an answer negative to the client's case. Then a quarrel starts between the advocate and the witness. That why didn't you say this one in the examination in chief? And the witness tells you, I was not asked. So it now becomes back and forth, you trying to outdo a damage that was created by your own self. So you try to avoid, once you've got a favorable answer, bank it, leave it. Avoid making inadmissible evidence admissible. Remember that if a conversation or a document was inadmissible in examination in chief. And you start examining on that particular document, that whole document is likely to become admissible. So if that document becomes admissible, you will have, if in effect, admitted in evidence a document that ought not to have been admitted, simply by now taking it upon yourself to examine on that document. I've seen, again, this happens quite often. A ruling has been made that that document is not admissible, and suddenly in examination, you now start asking questions on that particular document that was found to be inadmissible in evidence. I mentioned earlier on that in criminal cases, avoid as much as possible attacking the character of a prosecution witness. Because if you do that, in your cross-examination, you open the way for your client's character to be brought in question by the other side when your client takes the witness stand. I said, I've talked about where the answer may be unfavorable to your client. You don't ask it. It's better to leave a particular matter vague, hoping that in your submission, you'll be able to persuade a judge to agree with you rather than to take the risk of exposing your client to answer that is not favorable to your case. Do not ask questions to please your client or the audience. Do not ask questions for the sake of asking, in order to show maybe how smart or funny you are. Sometimes questions that counsel asks have completely nothing to do with the case. They're just meant to amuse. Your client is not really interested in amusement. Your client is interested in you winning the case. You have been paid to get the client out of the hook rather than to parade the skills. The court may be unsympathetic to counsel, where, for example, you are tasked you are the task of cross-examining a witness in a case that the public deems to be unpopular. Cases for example, sexual offenses cases, cases where there are serious injuries that have been inflicted on a particular person, cases where you are dealing with the evidence of a small child. Unless it is very necessary to ask questions, sometimes it's better to avoid it. As Commissioner Omwanza said, judges are not angels. They don't go to heaven maybe in the evening and return to earth in the morning. So they are just human beings who try as much as possible to ensure that their personal feelings do not penetrate or interfere with the decision they make. At the end of the day, you are dealing with a human being. Once you have achieved the gains you want to achieve, stop, bank your answers. Stop asking questions that are open-ended. Asking questions that open-ended and require explanation will simply put you into trouble. Do not cross-examine on a favorable answer. Otherwise, you risk the witness retracting what had been said earlier on in favor of your client. Keep the questions short. Asking a question one at a time and waiting for the answers. I've seen instances where you are counsel asks too many questions at the same time, but asking 5 questions at the same time. The witness has not answered the first one, you're already asking the 5th one. Or you are making, instead of a question, you are making a statement. By the time you are done with the statement, the witness doesn't even know what the question was all about. So make sure that the questions are short and to the point so that they can be answered and the court can then record the answers. In cross-examination, it said that you must think like a commando. You don't lay a siege, it's a raid. You go into a raid. When you go into a raid, you don't lay a siege. You get into it. Once you get what you are looking for, you get out. Don't stay in there for too long. I just give an example here, just like those who listen to music of Kenny Rogers and The Gambler, that you must know when to walk away, you must know when to run. When the time to run comes, better run very fast. If your cross-examination does not achieve any gains for your side, terminate it as quickly as you can. If your case is not getting any better, you have no business continuing asking questions that are likely to make your case worse. You know, sometimes when you ask too many questions and you are not getting anywhere, you know exactly what your opponent is going to submit. You're going to say that the witness was subjected to a lengthy, searching cross-examination by the experienced counsel. Of course, experienced counsel will be said with a tongue in the cheek and did not deviate from his evidence, did not contradict himself, or disclose any bias towards the accused. So the fewer questions you ask, the better, particularly if you're not getting any headway. Don't argue with a witness and don't seek for explanations. If the witness raises some matter that is argumentative, courteously ask the witness to restrict the answers to the facts. Ask questions in a way that you invite facts, not arguments and explanations. I'll stop asking questions like, why did this happen? Ask a witness, why did this happen? You can be sure that you are going to get a very lengthy explanation. Or you keep on saying, telling the witness that what happened after that, what happened after that, you are in real trouble. It is good practice to end cross-examination on a high note. Once the witness agreed with you, you better end that particular cross-examination. You should take care, as I've said, when dealing with the experts. You need a more detailed preparation than even examination in chief. Avoid as much as possible arguing with a witness. Otherwise, you are likely to fail to control that particular witness. Particularly if maybe that witness is more knowledgeable than yourself in the field in which he is giving evidence. As much as possible, be friendly to the witnesses. You want to get as much as possible from a witness, trust as much as possible to ensure that the witness feels that you are not an adversary. Try to make that witness be your witness. If the witness is rude, smile. A witness can be very rude, very offensive. But as counsel, you don't have to follow him into the gutter. However, once you decide to sever relations, friendly relations, then now you have to actually go full throttle and put all your arsenal into action. Suggestion is a very powerful weapon in cross-examination. It's advisable, however, not to try it on a child, unless you just want to show the court that the witness is susceptible to suggestions or has been inspired to tell a story. For example, you have a child and you are asking the child, is it not true that what you have told us today was what your mother told you to come and say, or what your father told you to come and say? The witness may actually tell you yes. But when you ask what exactly were you told to say, the witness may tell you, I was told to come and say the truth. So in effect, you have actually just made that witness to confirm that what the evidence that has been given is the truth. Do not be long-winded and avoid repetition. A point is not necessarily a bad one because it is stated with brevity, and a point is not necessarily a good one because you've taken so long to make it. Do not appeal to the court for protection against the witness. The chances are that you'll just be looking ridiculous and you are unlikely to get that protection anyway. It's better for the witness to seek the protection against you than you seeking protection against the witness. Of course, there's nothing wrong where the witness is not answering question to request the court to direct the witness to answer the question. In most cases, the court would do it even without you asking, but if that's the position, nothing wrong in drawing the court's attention to the fact that the witness is not answering your question. When dealing with hostile witnesses, from a tactical point of view, an application to declare a witness hostile should only be made if there are reasonable prospects of gaining some advantage by examining your own witnesses, your own witness. It's most probable that by the time you realize that the witness is being hostile, your case has already been destroyed anyway, and it's too late for you to do anything to prevent any more harm. So sometimes it's better just to ensure that you do not go to that direction once you realize that the witness is not giving evidence favorable to you. In any case, the evidence that witness is going to give in cross-examination by yourself is only meant to destroy his evidence, but is not meant to assist you achieve anything. Potential hostile witnesses ought to be identified in good time. Once you identify that a witness is likely to be hostile to you, better take the precautions in good time. A witness, for example, who refuses to come and for conferencing is a witness that you would be wary about. And as a rule of the thumb, never put a witness in the witness box whom you have not interviewed. Although you have all the latitude, you must be careful about your longitude. While cross-examination should be thorough, thoroughness is not the same as being lengthy. Cross-examination is not an avenue to roam at large over every subject under the sun. One judge said that protracted and irrelevant cross-examination not only adds to the cost of litigation, but it's a waste of public time. Cross-examine chronologically. If you do not, there are chances that you lose the thread of your story. The court may become impatient, lose interest in your cross-examination, and may miss a critical question. The witness may also lose respect for you. If you in your cross-examination, you are just rambling along. Always try as much as possible to carry the judge along with you in cross-examination so that the judge is with you as you move along. You don't leave the judge behind or lag too far behind the judge. Also remember that favorable evidence that you elicit from the other side has to be admissible. However, unfavorable evidence that you elicit from the other side need not necessarily be inadmissible. And that I had mentioned earlier on, they need to be very careful about the kind of question you are asking so that you do not allow inadmissible evidence to be admissible by cross-examination. Cross-examination is not cross-examination. Do not examine closely in cross-examination. Oppressive, insulting, abusive, sneering, and duly sarcastic cross-examination is generally not allowed. Insisting that a witness answers the question with a yes or no may not necessarily be appropriate, particularly if the question you are asking is not one that is capable of being answered by a yes or no. Do not abuse cross-examination. Gentleness and firmness both have their place according to the type of case and the reactions of the witnesses. However, it's possible to be firm without being domineering. A word where you add several defense counsel, particularly in a matter where there's no conflict of interest between in your respective cases, and more particularly where you are conducting a criminal defense. To me, my view is that it is advisable that you have some kind of a conference among yourselves, apportion the respective areas of examination, respective counsel. First, you minimize the amount of time that you are taking in cross-examination. Secondly, and most importantly, you are minimizing the possibility of one counsel destroying the gains that have been achieved by the other counsel in cross-examination. More often than not, a witness has given evidence, has not identified any of the accused persons. You are talking about, let's say, five accused persons. All the counsel appearing for the first four have not asked any question because their plans have not been mentioned. The counsel appearing for the fifth accused person, who also has not been mentioned, stand to examine and ask the witness that, did you see anybody at the scene? And now the witness says, yes, I saw number 1, number 3, and number 4. You can imagine the damage that your colleague has done to your case. But it's important that where there's no conflict with regard to the way in which you are going to handle the defense case, better to get together, agree on who is going to handle which aspect of the examination, or you can just agree on one particular counsel conducting examination as regards a particular witness. I think I've come to the end of my presentation. I have relied on a certain work. One is litigation skills for South African lawyers by C.G. Manewick, technique of advocacy by Mankman, and then there's the devil's advocate by Ian Molly. Thank you very much.
Thank you,
Very
Your
many
Lordship.
thanks, Justice Odunga, for that illuminating presentation. And I will just hand over to Karen, but before I do so, I found one very interesting, couple of interesting comments. Number one is that do not fight a witness, because if you do, the witness will fight back. You also said that that cross-examination is an invitation to disaster, meaning that once you open that door, then you do not know how far it goes. And lastly is that bank your good answers. Don't be too greedy. I'll first hand over to Karen. There are questions which have been asked in the forum so that she's able to raise them. And then perhaps if I have one or two, I can also ask. Karen.
Thank you. First, allow me to take this opportunity to thank your Lordship. There is a petition to change these webinars to be masterclasses because we've clearly covered a lot in just one sitting. And just to add two more to what Honorable Omwanza was saying, think like a commando and avoid an overkill. Know when to stop. So allow me, without further ado, to proceed to the questions that were raised, which were quite a number. I will start with Felix's question. As a tangent to enhancing effective cross-examination by advocates during trials, kindly also comment on how to conduct effective cross-examination during vetting and before other sui generis forums. So this is the outside the context of courts. With your kind permission, allow me to take 2 or 3 questions, then we answer, we go to a different batch, if that is in order. Your Lordship?
Yes, that's all right.
Okay. The next question is from Jack Ongaya. In a criminal trial, this is a defense case that has more than one accused person, with each accused person having their own lawyers. Is it advisable to cross-examine a co-accused person? Are there any implications? You may have made a comment on it, but kindly reiterate on the same. Then we have Mr. Emmanuel Obado, who has a hypothetical scenario I'd like to put you in. So I kindly request for your attention. You gave an example with an accused being pinned that he was found with a panga at the crime scene. The sentiments are said in spontaneity, timeliness, and relevance to the subject matter at the time. Will the principle of res gestae prevail? Then he kindly requested that you reiterate the difference between evidence in chief and examination in chief. So allow me to leave it at this point so that we can address those questions. Then we will get another batch. But feel free to our audience. I know we have over 1,000 participants on call, actually over 1,100 participants. Feel free to use the chat section. We will check on the YouTube page to see whether there are any other questions. Thank you very much. Over to you, Your Lordship.
Thank you very much. I don't know much about vetting, really. But I would say that the kind of question that you ask in vetting depends on the nature of the vetting, because you really cannot have standard way of dealing with the vetting. If the vetting is done for different purposes, and what is meant to achieve by a particular vetting may not be what you intend to achieve by another one. So there may be different questions for different types of vetting. The question of different lawyers appearing for different accused persons, whether it's permissible to examine a co-accused. Sometimes a co-accused may give evidence that is adverse to your client. And you know you are in that particular process because you have been instructed by your client to ensure that your client is freed. And in that event, you have an obligation to examine co-accused. And it happens, that's actually what happens. In most cases is that an accused is examined by co-accused. You don't want that adverse evidence to go on record unchallenged. The issue of the evidence evidence that is gathered at a scene, whether it's a register, that's this you know it applies where, for example, you are relying on evidence as a transaction, as a chain, that this particular witness was at the scene. The panga that was eventually found in his house was blood-stained. And you want to connect different events. For example, where the accused may not have been seen attacking the deceased, but the accused was the last person who was seen with the deceased. And later on, the deceased was found to have been injured using a sharp object. And when the police were conducting investigations, they happened to find a panga in the house of the accused. Now that's a chain of events. And that's where circumstantial evidence comes into play. Because unless you are able to explain, first of all, you are the last person who was seen with this person alive. What happened after you left this person? You know what happened to that person? How comes the panga was found in your house bloodstained? How comes the injuries that was sustained by the deceased were matching the ones in which a sharp object was used? So that's how it applies. Of course, we know that in circumstantial evidence, you as an accused person, you don't have to prove yourself innocent. What you need to simply adduce evidence that casts some doubt as to whether you are the one who committed that particular offense. The difference between evidence in chief, is that evidence chief and what, and the examination in chief?
Yes, so the difference between examination in chief and, examination in chief and evidence in chief.
Evidence in chief is basically the body of the evidence. That's the evidence, that's the body of the evidence. Examination in chief is basically the questioning by either the prosecution counsel or the plaintiff's counsel. Or if we are talking about the defense case, is the evidence that the defendant is giving. That is evidence in chief. The question that you are asking in order to elicit that particular evidence is what is examination in chief.
Okay, so I'll take the other batch. Allow me, I'm on YouTube, so there are a few questions that are being raised. Mr. Byron Menezes asks, when one is watching brief in a criminal hearing, what tangent should the cross take, bearing in mind the prosecutor is taking the lead? Then we had Mr. Mote Mungai. Your Lordship, how do you raise objections without being a nuisance? And back to our Zoom community, there is one question pending from Mr. Edgar Anungo. Can I cross-examine a party based on their cross-examination claims? What is the probative value of admissions made by an accused person while cross-examining a prosecution witness? Then lastly, should an
Maybe just repeat the last one.
Okay, so the previous one is, what is the probative value of admissions made by an accused person while cross-examining a prosecution witness?
Yes.
And the last and final question, so that we can close the Q&A section, however, I am not limiting our audience, is, should an advocate repeat cross-examination of a witness where the accused person had cross-examined, where the accused had cross-examined the witness by themselves, and what happens to the information in the former?
Okay, thank you. Now, watching brief. Under the old legal regime, an advocate watching brief was simply supposed to go and sit there and listen. Because the law was that the Republic is the complainant in all criminal trials. So the only thing that you could do as an advocate watching brief is to whisper the prosecution counsel that please ask this particular question. If the prosecutor declined to do so, then you do nothing much about it because you really had no audience. However, it is now appreciated that a victim is much part of a criminal process as anybody else. And therefore, there is an extent to which an advocate watching brief may be allowed to seek certain clarification from a witness who is giving evidence, depending on whether the court gives that particular leave. So there is an avenue which the advocate watching brief is permitted to bring certain issues to light in that kind of cases, because we appreciate the fact that the former law, the former position that the Republic, the complainant, may not ring true in this our current constitutional dispensation. I'm objecting without being a nuisance. Sometimes the instances where I have had to tell an advocate who is about to object to just retain the seat, because I know myself that the question that is being asked by the other side ought not to have been asked. And I tell the advocate who is asking the question that, can you please rephrase your question? Or I just tell the advocate that that question is leading. Go to the next question. So sometimes when you realize that the court is with you as you proceed, it may not be necessary to keep on objecting. Sometimes you actually become a nuisance when you keep on jumping up and down, I object, and you derail the trial. So sometimes the question that is being asked by that, it may be a leading question, but it's a harmless leading question. Why do you want to keep on objecting to those kind of questioning? If there's one that you feel that is really, really is really harmful to you to your case in the manner in which that question is being raised, raise it by all means. Raise it by all means, but don't keep on interjecting when the case is going on. And I mean, if you know the rules of the game and you know exactly what the evidence is, you don't have to keep on objecting. Sometimes when it comes to the examination, a totally new issue was raised in cross-examination. Totally new issue. And now the advocate for the plaintiff or the prosecution wants to have it clarified. And you are objecting to it being clarified. I mean, you are being fair. You are the one who introduced that line of questioning. You ought to be ready to also hear the other side. So it basically you need to know when to object. And sometimes in litigation, one thing that I think we need to keep at the back of our mind is that it's not always helpful to your client to keep on insisting that the law is on my side and I'm right. You take, for example, an issue of you apply for bail. Read the mood of the court sometimes. Read the mood of the court. The court may tell you that the bail is objected to. Well, nowadays you don't object to bail. The prosecution makes an application why an accused should not be released on bail. It's not that they're objecting, because the bail is a right, it's a constitutional right to everybody. So the prosecution is making an application that they are compelling reasons why the accused ought not to be released on bail at this juncture. The court tells you that gives a suggestion. How about tomorrow? Can we deal with this matter tomorrow? Depending on the nature of the case, you may actually consult your client, advise your client that maybe let's come back tomorrow. Sometimes when a court tells you to come tomorrow, you can be sure that maybe tomorrow you are going to get bail. Sometimes when you insist that let's argue it, you will argue it, the court will tell you that come for ruling after 14 days. You kept your client in for 14 days. This is why it's important as a counsel, as an advocate, that you must judge the scenario, look at which particular aspect best suits your client. If it's a matter where objection is now being raised for no apparent reason at all, oppose it by all means. If you feel that maybe the following day you may be able to get your client out, your client wants to get out by all means. Your client doesn't want to stay in for 14 days. You want to get out. So try as much as possible to ensure that you take a position by which your client gets out of police custody. The other issue was the probative value of admission by accused. There are two things. There's an admission and there's this confession. I think that's an area, a very gray area. There are certain areas, if you look at the jurisprudence that is developing or has been developed, there are certain statements by an accused person that may amount to an admission. Now, the courts have held that where it is a mere admission and not a confession, the rules of confession do not apply. Now, every case depends on whether a statement is admission or not. You have to look at actually the law and look at the substance of that particular statement. If a statement is given which really does not admit to all the ingredients and offense, sometimes the court deems it to be an admission. Where it is an admission of the ingredients of offense, of course it's a confession. And therefore the rules that guide confession apply immediately. And if you do not comply with those particular procedures, it will be thrown out. So it really depends on whether what you have is an admission or a confession. And in confession, of course, you must have to deal with the issue whether that confession is admissible before you can bring it in, and then you may be able to question the witnesses. Sometimes it is an admission that does not admit to all the ingredients of an offense. In which event, as a defense counsel, you ought to cross-examine the prosecution witnesses to bring out the fact that that particular statement does not admit to all the ingredients of an offense. So yes, where there's an admission, you ought to ensure that you distinguish between admission of the ingredients and maybe just admission of certain minor matters. I think the last question, if I got it right, you are referring to a situation, for example, where an accused person was initially unrepresented or was represented, but when the matter came for hearing, the advocate was not present. And therefore, that particular accused person proceeded with cross-examination, and at the next hearing, the advocate is now in attendance. And therefore, you are asking whether the advocate can still proceed with examination based on the evidence that was given at earlier proceedings. Of course, the court has the power to reopen a matter for cross-examination, but it's a power is something that you need to apply for, where you want the court to recall a witness for cross-examination or for further examination in chief. So it's possible, but it's discretionary. So you have to satisfy the court the reason why you believe that although that your client will examine the witness in the earlier proceedings, you ought to be given an opportunity to conduct further cross-examination. Unless I've left something.
No, you've adequately captured each and every question and answered it conclusively. Thank you. Allow me to seek permission from Commissioner. Do we still have time for possibly 3 questions, or are we at time bad? Please guide me. Kindly guide me. Commissioner, you're muted.
No, I think Judge has given us a lot of time this afternoon, and he's covered most of the issues. If anybody wants to go through the questions, I mean the presentation, they can go to the law series and be able to have a look again. But Judge, I have one question, an interesting question here that has been asked by, actually 2, asked by Felix Kiton. He asks whether a tribunal or a judge ought to give latitude to counsel to re-examine a witness if the judge himself or the tribunal descends into an arena of conflict and asks a damaging question while seeking clarification from a witness. Then the second question, my lord, is by Lydia Mwangi, who asks a very interesting question: that how do you recover when a client has been obliterated, for lack of a better word, during cross-examination by opposing counsel?
Thank you very much. I've seen some other comment there about where the co-accused has been mentioned. I'll deal with it, I think, last. The rules require that where the court is asking questions to a witness, those questions ought to be recorded as questions which are being asked by the court. They ought not to appear as questions which are being asked by the other side, so that the record is very clear that these particular questions were being asked by the court. Where the court descends in the arena, as it were, it's only fair that the counsel be given an opportunity to also deal with those particular issues, particularly if new issues are now being introduced. That to me is what fairness in a trial is all about. Because really you cannot, as a court, take over the matter as it were, when particularly in adversarial system, take it beyond the case that the parties have placed before you, build up a completely new case for a party, and then you don't expect parties to comment about it by way of seeking clarification and all that. Where your client's case has been damaged in cross-examination, that's what re-examination is all about. If you can salvage, then you try as much as possible to salvage by asking your client to clarify certain areas that may have been made vague in the process of cross-examination. Sometimes what counsel do in cross-examination is not really to destroy the evidence, but to weaken it. Sometimes they ask questions which are left hanging, and your client answers the question halfway and leaves it. More often than not, when your client wants to give a detailed explanation, the other counsel will tell him that no, that one I've not asked that one you leave it for your explanation during the examination. And those are the areas that you must watch out for. The examination is supposed to clarify certain vague areas that were brought up during cross-examination. It's not an avenue for starting examination in chief all over, which is what sometimes happens. And that's why it's very important to be attentive during cross-examination so that you identify the areas where you need your client to clarify in the examination. Okay, that's the only way in which you can try as much as possible to control the damage that has been caused to your client's case during cross-examination. There's something that I saw about where the co-accused has been mentioned. I don't know whether it was in relation to evidence by a co-accused. I need that. Maybe I saw it somewhere in the chat. Where some evidence that is adverse to your client is mentioned by a co-accused. That's why I said that in that event you may need to examine, because if the co-accused brings evidence that is adverse to the interest of your client, you have to come in and see whether you can have that particular witness explain the reason why that witness believes that particular evidence against your client ought to stand. You have to subject that particular evidence to proper cross-examination. I saw some other comment, maybe Ms. Rono, there's a comment that I saw and disappeared before maybe if you check the chat, you'll find it somewhere there.
Okay. But just before that, my blood is being paid for if I do not request you to repeat the books you reference. I got to Litigation Skills for South African Lawyers by Chris G. Marnewick, then The Devil's Advocate by Lane Morley, but the third one I didn't get, so I've quoted the two, but not the last one.
Okay, the first one I said was Litigation Skills for South African Lawyers by C.G. Marnewick. Then the Technique for Advocacy by Mankman. And then The Devil's Advocate by Ian Morley.
Thank you. I also can't seem to see the said question. However, please, kindly, Your Lordship, allow me to just read some of the really good remarks. We will not have done you justice. So Mr. Senior Chachamwita had really celebrated you. And for some reason, his comment has disappeared, but I'll start with the one that is next to me. Judge Odunga, your presentation and cross-examination was truly exceptional. The way you articulated the techniques and strategies was both insightful and practical. Your experience and knowledge have given us a clear understanding of how to approach cross-examination with precision and purpose. Thank you for sharing the expertise with us. Very informative session by Honorable Justice Odunga. We've shared the publication list. Everything is permissible for me, but not everything is beneficial from the good book. A truly valuable rule of thumb whenever tempted to raise an objection. Thank you so much. Allow me to give Commissioner to give the vote of thanks, but from our end and on behalf of the audience, the 1,200 of us, we are thankful for you availing your time and for spending at least 2 hours on your feet, explaining to us, quoting to us the good book and several other books. Thank you so much.
Thank you very much, although it's on my seat. Thank you, thank you.
Thank you, Justice Odunga, for sharing again your afternoon with us, and very important tools in terms of trial advocacy. In fact, when you started, you posed a question, if I might paraphrase that, at the end, let us find out whether it's still, whether cross-examination is still fit for purpose. I think I will leave that to the audience. But you've heard what the good judge has said, and that this is said from experience, from the bench, and also as a practitioner and also an academic. I wish to thank the entire team that was behind this, Brandon, Muriithi, Atieno, Ogolla, Dr. Gekombe from South Africa, Chrispin, Bosire, and Karen. Thank you for continuing to put these conversations for the purpose of learning and also, getting to know what the law says and improving our skills. Thank you, Justice Odunga. Have a good afternoon, and I think that will be the end for today. Asante sana.
Thank you, same to you.
Oh, for the ones asking, kindly, just check our YouTube page for everything. We will share the recordings